Thanks.
Yeah, the judgment, Cukurova Finance International Limited and another against Alfa Telecom Turkey Limited.
Lord Mance will give the judgment.
In September 2005, Alfa Telecom Turkey Limited, ATT, agreed to lend $1.352 billion to Cukurova Finance International Limited, CFI, at interest of 8% per annum over LIBOR. The loan was secured on CFI's 51% shareholding in Cukurova Telecom Holdings Limited, CTH, and on the 100% holding in CFI of Cukurova Holding AS, CH. These shares give control over Turkcell, Turkey's largest mobile telephone company. From inception, ATT's aim has been to obtain outright beneficial ownership of the shares and thereby to gain control of Turkcell. In 2007, when ATT knew that CFI was about to arrange refinancing of the loan, ATT identified an event of default and accelerated the loan. When CFI failed to complete the refinancing before the time for repayment of the accelerated loan, ATT exercised its right to appropriate the shares. Several proceedings have come before the board. In January this year, we decided that ATT had been entitled to appropriate the shares, but that CH and CFI were, under a surviving equity of redemption, entitled to recover the shares from ATT on terms to be decided. Just under 3 weeks ago, we decided upon the terms. CH and CFI were to be able to recover the shares on payment within 60 days of approximately $1.56 billion to ATT, plus further interest at 8% per annum over LIBOR accruing between the date of our judgment and the date of payment. On 10th July, Her Majesty approved an order in Council which included terms that CFI and CH have until 9th September to make these payments to ATT. Otherwise, the appropriation remains valid and ATT would be the absolute beneficial owner of the shares. Meanwhile, in September 2011, a company called Sonera Holdings BV had obtained an arbitral award for damages of $932 million against CH. Sonera granted an associated company of ATT, which may be treated as ATT for present purposes, power of attorney to pursue the award on the basis that any recovery would be shared between ATT and Sonera. ATT has sought to enforce the award in New York proceedings, in which the New York District Court has entered judgment confirming the award. In April 2013, ATT caused Sonera in these proceedings to apply for injunctive relief, purportedly in order to preserve the equity of redemption so that Sonera might take it over. In fact, this relief granted in the New York proceedings will make it impossible for CH and CFI, or very unlikely, that they will be able to grant security over the shares, which they would need to do in order to raise the required funds to comply with the terms on which we've granted relief. CH and CFI's appeal against these decisions to the United States Court of Appeals for the Second Circuit is due to be heard on 22nd August 2013. CH and CFI have now applied to the board, contending that the New York proceedings instituted by ATT in Sonera's name have, as stated, rendered it in effect impossible for CH and CFI to comply with the terms of relief contained in the order in Council, and that the board should vary that order. They seek an extension of time beyond the 9th of September to recover the shares and seek relief relating to interest, particularly its termination for the time being. The board heard oral submissions on this application last Tuesday. We've concluded that there can be no real doubt on the evidence that the dominant reason why ATT has taken the steps it has taken in and since April this year in the New York court in the name of Sonera is in pursuit of its aim of preventing CH and CFI from redeeming the shares. As a result, CH and CFI are being intentionally and seriously hampered by ATT in their attempts to raise money. It's impossible to say that there would be no real prospect of redemption if CH and CFI were not being thwarted by the steps taken in the New York proceedings from raising the necessary funds to redeem the shares. If the Second Circuit Court of Appeals if the Second Circuit appeals were to succeed, there would be a real prospect of redemption being achieved by CH and CFI. In these circumstances, the board makes an order along the following lines in summary of the main terms. First, CH and CFI are granted an extension of time without a cut-off date to recover the shares although an application to fix a cut-off date or for other relief may be made by the parties either on a change of circumstances or at any time after 1st December 2013. Second, the running of interest at the rate of 8% per annum over LIBOR is suspended as from today on the ground that CH and CFI are currently being prevented from redeeming the shares due to the actions of ATT in the New York court. Third, if the New York court orders, which have the effect of preventing CH and CFI recovering the shares, are reversed on appeal, then interest at 8% per annum over LIBOR will start to become repayable, subject to any other date that the parties may agree or the board may order, after the end of a further 19 days. That 19 days takes account of the 19 days for which interest has already accrued since the order in council.
Court is now adjourned.